Petition is not pressed. The memo is taken on record. The above petition is dismissed as not pressed.
Page number 4, page number 20 to 23. Page number 5, page number
31.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನಪ್ಪ ಅಲ್ಲ ಬೇರೆ ಯಾರು ಬರ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ
ಬರ್ತಾ ಇಲ್ವಾ?
ಎಸ್ ಮೇಡಮ್ ಹೇಳಿ.
ಮೇಡಮ್ ಇದೆಯಲ್ವಾ ಸಿಟ್ಟಿಂಗ್ ಸಾಹೇಬ್ರು ಬರ್ತಾರಲ್ವಾ?
ಬರ್ತಾರೆ ಮೇಡಮ್ ಬರ್ತಾರೆ.
ಓಕೆ, ಯಾಕಂದ್ರೆ ಬೇರೆ ಯಾವ್ದು ಕಾಣ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ ಮತ್ತೆ. ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
Oh, just it.
Is not listed. And that's what post along with so and so when. Yes.
One submission, my lord. One submission.
The request of land council April 460. Yes.
My lord, serial number 12, my lord.
Yes.
This matter is connected with MFA 943/20.
Hmm.
May kindly be ordered to be posted along.
What is the number?
940/20.
Post along.
943/20.
Yes. Yes.
Number 22 to 29.
Number 24.
Post along with MFA so and so. MFA so and so next week, Monday.
Number 30 to 31. 38 to 41.
Serial number 37, Your Lordship.
37.
Your Lordship, liability DL is involved. Your Lordship may kindly post it along with the batch matters.
Post on September 19th, along with the
Yes,
batch.
sir.
Yes.
Much obliged.
40? No. 45? Yeah. Monday.
Lordships kindly
Yes.
serial number 32 and 33. Renuka madam is today attending Dharwad High Court bench. She's raised for a short accommodation. 32 and 33.
If you want,
And any day next week, it's all right.
Tuesday,
Obliged.
the request of land council respondent.
One submission, my lord.
Yes.
My lord, serial number 30, my lord.
Yes.
My lord, this matter is connected with 9629/2017. I have filed the appeal in that.
Take that number, post along with that on Wednesday.
9629/17.
Yes.
Please, ma'am.
Yes, next.
Okay. And second one. Number 1, attachment. Sitaram Rao Desi.
Yes. What's the mark? Here is the council with respondent. Yesterday also is not present.
Swami. Raghun.
How much is granted? 40,000. Was the compensation? Yes. The present appeal is filed by the insurance company aggrieved by the award passed in MVC number 2057 of 2006 dated 21st July 2014. The claim petition is filed seeking compensation of an amount of 25 lakhs for the injuries sustained by the claimant in the road traffic and the accident dated 18/6/2003. The case of the claimant is that on 18/6/2003 at about 6:30 a.m., when the claimant along with others proceeding in an auto, the offending vehicle came driven by its driver in a rash and negligent manner and dashed to the petitioner's auto due to the said impact. Petitioner sustained grievous injuries and taken treatment at SC Hospital, Hassan, as inpatient for 1.5 months, and then at Imhan's Hospital, Bangalore. He has spent more than 30,000 towards medical expenses. Earlier, the court below has allowed allowed the claim petition, and against that, MFA number 8068 of 2009 was filed, and this court, by judgment dated 29/2/2012, this court has remanded the matter as it is a case of the respondent insurance company that there are interpolations in the cover note, and as per the policy, that it is with effect from 11/6/2002 to 10/6/2003. As they have not filed the policy and the register of payment and also not produced the payment register, the premium payment register, the matter was remanded by this court. After the remand, the court below again dismissed this, has again passed the order granting compensation of an amount of rupees 40,000. The case of the insurance company before the court below is that the offending lorry was not insured with the second respondent on the date of accident. After the remand of the case, they got examined administrative officer as RW1 and got marked exhibit R1 to R5. According to the respondents, the vehicle was insured with the second respondent for the period between 11/6/2002 to 10/6/2003, and the accident occurred on 18/6/2003 after the expiry of the policy period. But the claimants placed before the court a cover note for the period 11, which a cover note showing that it is from 11/8/2002 to 10/8/2003. In the said cover note, they have fabricated their interpolations, whereby in the months in place of 6 is being corrected as 8, and they have filed the same before the court. It is contended by the insurance company that the claimant has paid fraud on the court. The court below on this issue has held that that the length end of left side of exhibit P8, that is the cover note is perused. The date of issue is mentioned as 10/8/2002. And according to the learned counsel with the respondent number 2, the date of commencement of exhibit P8 is from 11/6/2002 to 10/6/2003. And if that being the case, the date of issue of exhibit P8 ought to have been 11/8/2002, 11/6/2002, and not 10/8/2002 as mentioned on the corner of exhibit P8. Basing on that, the court has come to the conclusion that there is an existing policy as on the date of the issuance of, as on the date of the accident. What did you come here? In the interpolation earlier, dictated, no, in that there is an interpolation in the date as well as the issuance date also. Then counsel appearing for the insurance company submits that the court completely failed to appreciate the exhibits marked on behalf of the insurance company, that is exhibits R1 to R5. It is submitted that the claimant conveniently has filed only the cover note, but failed to file the insurance policy which was issued. The insurance policy clearly shows that the policy is from 11/6/2002 to 10/6/2003. He submits that after the accident, the owner of the vehicle has taken another policy, that is from 13/8/2003 to 29/8/2004. They have also marked exhibit R4 the premium register extract before the court below, which shows that he had paid the premium on 11/6/2003. And by filing the same, they could establish before the court that a fraud was paid by the claimant for getting the compensation. This matter was listed on 28/8/23, and as there is no representation, it is directed to be listed on 29/8/23. Again on 29/8/23, on that day also there is no representation on behalf of the respondents. The court has heard the learned counsel for the appellant at length and for giving an opportunity to the respondent. The matter is adjourned to today, and the matter is posted today under the caption for judgment. Today also, there is no representation on behalf of the learned counsel for the respondent. And this court is inclined to decide the case on the available material on record. This court has perused exhibit R2, the policy, which clearly shows that the policy date is from 11/6/2002 to 10/6/2003. Further, the exhibit R5, the premium register extract, strengthens the case of the respondents as the premium was paid on 11/6/2002. When the premium is paid from 11/6/2002, the question of issuing the policy on 11/8/2002 does not arise, even though the bare perusal of exhibit P8, the insurance cover note discloses that at 3 places, the numbers, the 6, that is the month June, is corrected as 8, show that as August, and to get the compensation amount. The quote below failed to consider the evidence adduced on behalf of the respondents, and looking at the issuance date at the bottom, the date of issuance has come to a wrong conclusion that that there is a valid policy as on the date of the accident. In view of the above discussion, particularly looking at exhibit R2 to R2 and exhibit R4, this court has no hesitation to come to the conclusion that there is an interpolation, and as on the day, and the policy is was in effect from 11/6/2003 to 11/6/2002 to 10/6/2003. And the accident has taken place on 18/6/2003, and as on the date of the accident, there is no policy existing, and hence the insurance company is not liable to pay the compensation. The compensation so awarded by the court below, the owner alone is liable to pay the compensation. Accordingly, it alone is liable to pay the compensation. The amount that is deposited by the equated to the court below, and he is at liberty, and the insurance company is at liberty to withdraw the same. Yes. Next. Next. So you're saying para number? Para. He was diagnosed having the injury of left ankle, subluxation with medial malleol, type B open fracture, closed fracture of proximal side of right humerus with radial nerve palsy, oblique ramus fracture, I see. So there are 4 fractures. No, you just want the court to see that how the judge has granted. No. Absolutely, the court is open. Court wants to know from you on law. No. Of course. So you don't have to hesitate and tell it. Being an officer of the court, you have to assist the court. Yes.
See, it is discretionary power to grant the concept nature of the allocation of the basic all other aspects of
No, what is your submission that if the court? No, I'm just, please listen to the court. No, according to you, if on a disability aspect, if the court consider, no, if the court considers and grants the compensation by applying the multiplier and all, then under the, what is then where, in which case about this 40,000 per fracture can be granted?
constant.
No,
That
let's
is only argument.
no, I understand. Then in which case the apex court for this, for the, whenever a fracture, there is 40,000 was, that's what the, no, there is,
Any observation that depends upon it, it will change from case to case.
no,
Facts.
there are like for fracture, simple injury 10,000, fracture 40,000. In one of the judgment, Supreme Court has, I gone through the judgment. That's why I started adopting that. That there is, it's like,
It's only
no,
property.
no, you don't have to.
That I not the other judgment of the effects. They say that it is a paraplegia and all.
They granted a very huge amount. No, if you can pay something before the court on this, definitely will follow. There should be some uniformity. What I have been following is wherever the fractures and other cases are there, I exactly don't remember the judgment. Where they have clearly said, then it was always a submission of the advocate that that's the latest law of the Supreme Court. Accident had happened long back, so that 40,000 shouldn't be given. But there is a judgment of the Supreme Court that for this grievous fractures, this much, simple injury, this much, should be the compensation.
The compensation under the parents of
No, yesterday you have seen in one judgment, the same, for the same leg, there are 2-3 bones fractured. So in that case, we were not taking 1, 2, 3. That is only one fracture. So no. Any judgment, anything you can place before the court, because ultimately law has to evolve.
If paraplegia and amputation, there's physical pain. Therefore, has to be compensated for. Therefore,
then we'll do one thing. No. Then we'll do one thing. What we'll do is, if in a particular case there is no disability, so we are not granting any amount. No, just listen to the court. When we are not granting any amount by applying the multiplier, that's what I mean. In that we will do. No. What I'm saying is, not only in your case, in all other cases also, wherever there is this court is granting any compensation under the head loss of income because of the disability, in that case, so we will grant some lump sum amount for the pain and suffering. And if it is not granted, in that pain and suffering, all 40 into so and so. So let's see what is this case. Let us see what was the claimed compensation? 20 lakh. 2 lakh? Come to that para of the judgment. Para 11. Inter-counter part. Here in para number 13, children between the age of 10 to 5 years, the notional income is 15,000. That is enhanced by the Supreme Court in the other judgments to 30,000. Kulwant Singh and later Mini Raut or the Justice Maheshwari's judgment. So we will take 30,000. So then again, why the court comes to saying 20,000 per annum? So we will take 30,000. We'll take it as 30,000 per month, per annum. What is this at page number 15? Last line. No, in this, it is the petitioner suffers with physical disability of left lower limb 30% and 10% to the whole body. Then when it comes to 15 page, something else is discussed. 15 bottom. Hmm. It is 19%. It is 10%. The two doctors have given two opinions.
There are two doctors, one is doctor, another one is.
So court has finally taken 10%. Under this caption, I will not grant any amount, loss of income during the laid up period. That will not grant. Compensation for disability, sustained loss of happiness. Future. So this should be happiness and amenities. That is 30,000 into 15, 10%. So multiplier is not 15, it should be 18. Is it so? Even that latest judgment, give that 13 to 15.
Correct.
Yes, 13 to 15, that's what it is. That is 45, 4,50,000. No, no, not necessary. What is the age of this boy? He's 18. He's 18. Huh? 15 years. What is the other view?
So, in that case, when I enter another case where he was attaining 18 years, declared method was applied, right to grant. The emotional income to be taken into consideration, that was the key difference.
Comes to 45,000. $10,000 towards medical expenses as is given. Future medical expenses is around 40,000. There is no much. Incline 30,000. Future medical expenses. Where will, what is this 12,000? How can well, loss of income during laid up period, that the compensation for disability, loss of happiness and future and medical, and how many days he was in hospital? Transport, extra nourishment, and attendant under the said head will grant 20,000 for all the three. Then now let's come to the pain and suffering. Pain and suffering that the court has not yet granted. How much it was granted? How many are the injuries? Three. So now we'll grant 60,000. Comes to 3,12,000. For that, he will not be entitled. 250. It is condoned already. It is condoned already.
Yeah, not better, right?
Please look at it. In the back of it. Not there? Oh, that's not condoned. Hmm. Where is the IA? A number? A number 1 of 2000, that's a separate order. A number 1 of 2014 is filed to condone the delay of so and so days in filing the appeal. No counter is filed by the respondent for the reasons stated in the accompanying affidavit. The delay of so and so days is condoned. However, the claimant will not be entitled for interest for the said period of so and so days in case of enhancement of compensation. That's a order in the IA. Now take the order in the. There is an appeal filed by the about passing MLC number 1147 of 2011. Compensation an amount of 20 lakhs for the injury sustained by the claimant in the road act. The case of the claimant is that on 17/1/2010 at about 6:45 p.m. The driver of the lorry drove the same in a rash and negligent manner and dashed against a motorcycle which was coming across the highway. As a result, the petitioner, who was a pillion rider on the said motorcycle, had sustained grievous injury. The claimant was 16 years old as of the date of the incident. It is submitted that he has sustained 3 fracture injuries and also because of the said injuries, he has also sustained a disability which would have impact on his future prospect. It is the court below, considering the evidence on record, has considered the disability at 10% as a doctor who has treated has deposed before the court that he had sustained physical disability of 30% to the lower limb and 10% to the whole body. The court has considered, as he is a minor, considered the income at 20,000 as a notional income, and by applying the multiplier of 15 and considering the disability at 10%, has granted an amount of rupees 30,000 towards loss of earning due to disability. An amount of rupees 40,000 for the pain and suffering. Towards loss of income during the laid-up period, 12,000. Medical expenses as claimed by the claimant, an amount of rupees 1,37,000. 10,000 towards deformity. Future medical expenses, as it is the case of the claimant that it requires 40,000 for the operation, court has granted 12,000. Altogether, an amount of rupees 2,41,000 was granted by the tribunal. This matter came up for hearing on who's the docket? At the request of, he was present yesterday. Instead of writing at the request of learned counsel, the respondent, they wrote appellant. At the request of learned counsel for the respondent, the matter was posted to today. And yesterday also there was no representation. Today also there is no representation on behalf of the learned counsel for the appellant. As is an appeal of 2013, this court is inclined to proceed on the merits of the matter, basing on the material on record. As per the evidence of the doctor, he had sustained, claimant had sustained, he was aged 16 years and he had sustained trochanteric fracture left femur. Page number 20, write down this thing. And according to the doctor, those injuries are grievous in nature. And because of the injuries, that there is persistent stiffness in the knee and hip with difficulty to squat and sit cross-legged. The range of hip movements that is also at page number 22. Extract A to E. A to E. And the doctor PW2 opined that the disability is 10%. However, the other doctor PW3 has stated that the disability sustained is 37% to the left lower limb and 19% to the whole body. The court below has considered 10% as rightly considered as 10%, basing on the evidence of the doctor who has treated him. But when it comes to the notional income, court had taken 20,000. The Honorable Apex Court, which case is that Kurwan Ansari or what? Kurwan Ansari, and which has followed in the later judgments, had taken the notional income. The citation you have today, Kurwan Ansari, that is there in the index. No, that's there in the index. Look at it. Kurwan Ansari taken 30,000 as a notional income. This court is, hence in the light of the settled law, this court is inclined to take 30,000 as a notional income. 30,000 into 15 into 10 by 100 is 45,000 towards the ugly scar court has granted deformity, an amount of 10,000, which is a reasonable amount. And towards medical expenses, 1,37,000 is granted, which is also based on the evidence. And coming to the future medical expenses, according to the claimant, he requires 40,000 for the future expenses. Court, without any discussion, had granted 12,000. Court deems it appropriate as it would be a very that amount would be on a very lower side, and a surgery cannot be performed. The expenses of the surgery cannot be that low. And for future medical expenses, the court is inclined to grant 30,000. The claimant was in hospital for a period of 1 month. 1 month. But for the transport, extra nourishment, attendant charges, no amounts were granted. Hence, in the facts and circumstances, 20,000 would be an appropriate amount under the 3 heads. The court has granted an amount of rupees 10,000 for what is that expenses? Loss of income during later period. An amount of 12,000 is granted. Admittedly, he is a minor, a student, and the court below, without any basis, has granted the said amount. Add that one. Then we will interpret like that. The court has granted loss of income during the later period, an amount of rupees considering 4,000, has granted for 3 months an amount of rupees 12,000. Then counsel for the insurance company supports that as he is a minor and is not a non-earning member, court below or not have granted the said amount. As rightly pointed out by him, the minor is not an earning member, but as the minor was not well, the parents have to take care of him, and in that process, they might have lost the income. Hence, the court below justified in granting 12,000 for the loss of income during the later period. Then coming to the pain and suffering, he has sustained 3 grievous injuries, and the court below has granted only an amount of rupees 40,000 for the injuries sustained by him, and considering the age under the head of pain and suffering, this court is inclined to grant 60,000. Altogether, the claimant is entitled for an amount of rupees 3,24,000. Accordingly, appeal is allowed, enhancing the compensation from 2,41,000 to 3,24,000. So all the clauses will be claimed, but the enhanced amount affects 6% interest. Give that to him. Now for the delay period, there was a delay of so and so days. Just to they have taken down now. For the said delay, the delay period, the claimant is not entitled for interest on the enhanced amount. Yes, sir. Yes. What is the IA that's coming up now? Unknown deliberately. How many days? 1, 2? By the insurance company. Appeal by the insurance company. By the claimant. Then will unknown the delay on the same, like they're not entitled for any interest on that period. There is a delay of IA number so and so. There's a delay of 1,261 days in filing the appeal. No counter is filed with the respondent for the reasons stated in the affidavit. The delay of so and so days is condoned, and the claimant will not be entitled for the interest interest for the for the interest for the delay of 1,261 days in case of enhancement of the compensation. Yes. Hmm? What is this is what is yesterday's R2 is claimant, driver of the vehicle. Hmm. You appear for who? R1, the liability is on you. Then will the notice will be the yes. The code below, that should be in the docket order. The code below has fastened the liability on the third respondent. Then counsel for the petitioner submits that notice to the second respondent is not necessary. Accordingly, notice to the second respondent is dispensed with. Yes. What was the claim? How much was granted? Any disability?
Not 8% disability. 21%. The evidence of the document is not at all taken into consideration. Judge has not decided not the matter. As if there is no evidence.
So in that case, PCR had to be called in this case.
Yes.
Then we call for the TC to have the
All the ticket copies. Telephonically, we will part of the next.
history is directed to call for the lower court record. Pose this matter next Friday. The call for like that. Call for the lower court.
My lord, I am for the appellant, my lord. This is serial number 4, my lord. Serial number 4.
Yes.
My lord, I have to take steps to respondent number 6 and 7.
You have not
My lord,
deposited 50% amount.
My lord, we have deposited before the tribunal, my lord, but have not produced the acknowledgement.
Why?
I'll produce it, my lord. This is for the first time it is coming up for seeking production of.
Time will, if for
But
the acknowledgement is not
somewhere in
produced, we will pay the stay.
16/3/2017, we have deposited amount before the tribunal.
Then now notice is pending to whom? Who are 6 and 7?
6 and 7 are parents, blood petition number 1 to 5. I think Mr. K.C. Pradeep may be there to take
Okay.
notice on behalf of them also. They are also claimants. They are also claimants.
Then counsel for respondent submits that 6 and 7 are the parents of the deceased. He'll get instructions in this regard.
Records may be called for, Mela.
This is directed to call for the records. Pose this matter to. And by the time the learned counsel for the appellant shall file before the court the acknowledgement evidencing the deposit of the 50% of the compensation. Yes.
Please,
Yes.
Mela.
Please, Mr. Chandrasekhar. Yes, for dismissal, none appears on behalf of both the parties. Yes, next.
My lord, serial number 6, my lord.
6, sir.
I am for the respondent number 1. I am ready, my lord. Ready for the.
No representation on behalf of the appellant, counsel for the respondent present for dismissal. Yes. Number 7.
It can be disposed of.
Number 2, yes. No, no. Mr. Vijay Kumar is ready, he says it can be disposed of.
Yes, my lord.
Huh? Medical records are required in this. Oh,
It's a simple injury, my lord. It has considered all those aspects.
how much you claim?
3 lakhs.
What are the injuries?
Right?
All simple injuries. All simple injuries. What we will do with the medical record? Let's see the let's hear the matter. Let's see if necessary we'll call. Mm. Mm. Yes. How much court granted?
42,000.
40?
42,000.
I think you claimed for the first time I'm seeing some claim like this. Your claim okay, has claimed very less amount. For everything it should done about 10 lakhs. Yes,
Finance happened in the order, but by
but let's see, please come to the order.
issue number, pay number.
Number?
So that he has the same cut class, right? Like,
No, your issue, it's not on liability, it's only on, let's go to issue number 2. Yes, please read.
that's it. Subsection of vehicles. 8, 9. He was admitted, shifted to VK hospital. Thereafter, referred to Santosh hospital. Inpatient for 28/9/2011 to 39/2011.
Date of accident is on 28/9.
28/9. CT scan taken in the said hospital, that is in Santosh hospital. Temperature, right? Temperature, partial swelling, right? Pictorial, but right side. Spaced fracture of left side. Arch and fracture of.
So why suddenly this has come into picture, fracture?
CT scan. The document is produced. Exhibit B40.
That's why the court said that. It cannot be believed at all. Petitioner has not produced X-ray to show that he has sustained so and so, so and so. Can
Can
we?
be awarded. Can be awarded for.
he has taken treatment for age-old related ailments, which is not way directly connected with the injury sustained in the accident.
No, it appears that he is in hospital for some time.
Yes, one for his age-old related aspects for BP and other things, not for the injury sustained in the accident. He has taken treatment only for 2 days. He has taken treatment only for 2 days.
8 days, 28 to 30 days.
Maybe. Therefore,
Maybe.
Malad tribunal has awarded Malad 42,000. Malad another 30,000 may be awarded and close the matter.
Incidental as to the side of period. And so how many days?
What were you doing?
67 years at the time of accident.
I don't think you can ask for anything more than that. So towards that, whatever amount is, we will grant under pain and suffering. 25 is granted. Another 30, as he says, slightly 55,000 is.
I am very fair, my lord, in making my submission.
Will come to 82,000. 82,000. 1357 days. First, take the order in the IA. There is delay of so and so while 1,307 days in filing the appeal. No counter is filed for the reasons stated in the affidavit. The delay of so and so days is condoned. The
Without interest.
petitioner will not be entitled for interest for the said period in case of enhancement of the compensation. The next another order. The petitioner has filed a memo to dispense with notice to the owner of the vehicle. As the tribunal has held that the insurance company is liable to pay the compensation, the notice to the owner of the vehicle is dispensed with. Next, the appeal. There is an appeal filed by the claimant, agreed by the award parts in MBC number 7627 of 2011, dated 12th December 2012. The claim petition is by seeking compensation of an amount of rupees 3 lakhs for the injuries sustained by him in the motor vehicle accident. The case of the claimant is that on 28/9/2011, he was crossing the Devegowda Road near Munireddy Palya, that time at about 8:40 a.m. The driver of the auto drove the same in a high speed in a rash and negligent manner and dashed against the petitioner. As a result, he fell down and sustained injuries. Immediately was shifted to the hospital for further treatment. He has spent an amount of rupees 1 lakh towards the treatment. As per his report for the court that he has sustained cut lacerated wound over right leg, hematoma around left eye and left parietal region, abrasion over left forehead, right finger and right big toe. What is the subluxation of left acromyoclavicle joint in the accident? He has taken treatment in the hospital for a period of 3 days. Later, he was discharged. Then the court below, under the head of pain and suffering, granted 25,000 toward transportation 2,000, medical expenses 15,000. Total an amount of rupees 42,000 was granted. Then counsel appearing for the appellant claimant submits that petitioner has also sustained, the claimant has also sustained fractures, and the court below has not considered the medical evidence. He submitted that he is in hospital, and because of, Because of the said injuries, he couldn't work, and during the later period, no amounts were granted. For the loss of income during that period, no amounts were granted. He submits that the compensation amount that was granted by the tribunal was not reasonable. When counsel appearing for the insurance company submits that the claimant was 67 years old as on the date of the incident. For all the simple injuries he sustained, he has taken treatment in hospital for 3 days. All other X-rays and other other medical records do not have any nexus with the accident, and they are all related to the age-old problems of the old age problem of the claimant. He submits that the tribunal, considering the evidence, has rightly granted the compensation. He submits that at the initial stage, nothing has been stated about the fractures and all. Later, the case was developed saying that he has sustained the fractures. It is submitted that the court below has observed that the X-rays were not, no X-ray was produced to show that he has he has sustained fractures. When counsel for the insurance company submits that the claimant had failed to make out any grounds for seeking enhancement of the compensation. As per the evidence, as stated by the petitioner, all the injuries that were sustained by him are simple in nature. For the fractures which were later developed in the evidence, no X-rays were filed before the court. Even for the later period, income during the later period, no, as he is 67 years old, nothing has been placed on record to show that what is the income of the and how, and with this simple injuries, what is why simple injuries, why he couldn't work in view of the same. He couldn't work. But as he is aged about 67 years, the injuries that he has sustained, under the head of pain and suffering, court has granted only 25,000. The considered opinion of this court, 55,000 would be an appropriate amount toward transportation, medical expenses. The court below has rightly granted 2,000 and 15,000 respectively. And towards legal expenses, as per the law laid down in terms, they are entitled for an amount of rupees 1,000. Altogether, the claimant is entitled for an amount of rupees 82,000. Accordingly, appeal is allowed by enhancing the compensation from 42,000 to 82,000. The claimant will not be entitled for the interest for a period of 1,357 days. The enhanced amount would the 6% interest. Yes, next.
Much obliged.
Yes, next.
Seven.
Keep it in the file. So when you're not taking steps for R1, then what to do? Claim petition is this one. Petition is permitted to take out notice to the respondents. In all 7.1 and 7.2, in all these cases, pose this matter after 2 weeks. By the time the steps are not taken by the appellant, appeal will be dismissed or not.
Yeah.
Lower court Ministry is directed to call for the lower court records. Huh? This is solved.
Number 8. A. Venkatesh.
Oh, my lord, I am appearing for the appellant insurance company, my lord. 8 to 14 are all the appeals filed by the insurance company, my lord. In all the cases, I am to take steps R1 and R2. In certain cases, only for the owner. In remaining cases, 1 and 2, I have to take. 2 weeks time, I will take what required steps, my lord. 8 to 14, my lordship.
My lord, one submission, my lord. In the morning, my lord, by mistake, I made serial number 12 is connected with this matter. I'm very sorry. There is no connection. I got confused with other court matter. Sorry.
What did you say?
In
Serial
serial number 12, this
Uh,
matter is connected with another matter, but actually it is not so. By mistake, I have made it submission.
yes.
There is no, it is not connected with any other matter
Yes.
of other.
So
side.
from item number 8 to item
14.
number 14.
14, please.
You have to take notice to
In some cases for R2 owner and in some cases, so claimant as well as the owner, my lord. I will take required steps, my lord.
the in batch of in this item numbers 8 to 14. In some cases, notice is not served. Notice is not taken to R2 and in some cases to R1. The land counsel for the appellant submits that he will take steps and seeks a 2 weeks time.
Please.
By the time if the steps are not taken, these appeals will be dismissed on that ground.
Please.
Yes.
Number 15.
Hmm? Finally, matter is that a week's time is granted to the appellant to take steps, or else the appeal will be dismissed on that ground. Same, give the date also.
11 September.
Yes. Hmm? 8 to 14, yes. You know, this matter is 15. What is called is 15.
Number 16. Angaroda.
No representation for. You appear for the respondent. No representation on behalf of the appellant. Counsel for the respondent present. Post for dismissal. Give that and post along with take that slip. It is disposed of. Let's see, let him come or else we'll look into it and pass orders. Post on so and so. Yes.
Number 18.
My lord, it may kindly be passed over, my lord, I will appear. By 2:30 I will come down. It may kindly be passed over.
Which one?
18, my lord.
Pass over.
Okay.
Pass over.
20.
I am for the respondent, my lord, in 19.
19, matter is adjourned.
Oh,
When is it posted? Next week.
much obliged.
Number 20. Gangadhar Rangoli.
Seeing no representation for discussion on either side. Yes.
Number 21. Suraju MS.
Same order.
Number 22. Yeah, Prasad.
Same order. Counsel for the respondent present. Land counsel for the respondent present. It is submitted as a copy of the appeal memo. Is not served on him. No representation for the appellant for discussion.
Right. Serial number 23. A. Nangareddy.
When you're taking till 4/9, but especially you can have F tomorrow also.
On Friday, my lord, so I'm taking it on.
Oh. Same or you appear? 23.
Serial number 23.
Yes.
Serial number 24, adjourned. Serial number 25. Shashidhar.
Same.
Serial number 26. Shankar SS.
Same.
Serial number 27.
My lord, I appear for the appellant, my lord.
Which
TCR
matter?
27, my lord.
Yes.
TCR may kindly be called, my lord.
Huh?
The trial court record is not yet called. Kindly call TCR, my lord.
It appears if you are not at called. Why is it necessary?
My lord, evidence I have to read. There is a clear-cut evidence that the claimant admits that I was drunk without knowing the consequences. I crossed the road. I was
Please-
not in some
Please,
state of mind.
please call for the lower court record. Post this matter after 10 days. Give the date. Yes, next.
11.
Yes.
11 9. Serial number 28, Raju S.
You for the respondent. Who appears for the appellant? Well, let's hear the matter.
28.
Lower court record required. Please be directed to call for the TCR. There is no representation on behalf of the appellant. Counsel for the respondents 1 and 2 present. Post this matter for dismissal after 2 weeks. He is not here. Yes.
Serial number 29.
You appear for, yes. This is a copy of it. No, you don't have to file any objections to that. No. No, difficulty is it's an application filed as per the procedure. Unless and until you file your objections, that means you're accepting it. File a formal application. And also the respondent submits that an application is filed under order 41 rule 27. He'll come up with his objections. How much time? My post on Monday. We'll hear on that date, sir. But no, then the evidence has to be used.
They are not trusting upon the daily law.
Yes, because if the court has to take that on record, then the evidence has to be adduced. Yes. When do you want? On Monday. Let it come on Monday. Just at the request of learn counsel for the appellant, post on Monday. Remove the other thing. Which
Yeah.
That's why. I said not for that, for Monday. Yes. Yes.
Number 31.
Just for discussion. Yes.
Number 32 and 33 adjourned. Serial number 34.
Yes, Mr. Venkatesh,
Oh, my lord.
are you ready?
Yes, my lord, but it may be passed over.
All matters passed over. What the court has to do now?
230.
Also,
Till number 35, is Sita Ramra.
why? Bundle is not there. It's there. Bundle is not there. Let's see. Give the file. Appeal by the insurance company. How much was claimed? 25 lakhs. How much was awarded? Let's read together. 6,06,000. You are on liability. You're only on liability. Let's read that issue. Or I'll pass over then. Please go through. Because it appears to be a very simple one. Yes, pass over. Yes. Typical. No representation on behalf of either side. Yes. Yes. Mr. Mahesh,
Number 38,
yes, for dismissal. Matter. Why? Request of land counsel for the appellant. Causes matter. You can also argue old appeal. The request of land counsel for the appellant that it is submitted that the land counsel the appellant is not feeling well. Causes matter after 2 weeks finally. What about 39?
till number 39, denied file.
He wants a passover. We'll decide this matter today. Yes.
Denied passover. Till number 40.
Please argue. What is this? What is the claim for? How much is the claim? Dismissed. 50 the file. Does see why it is dismissed? How many days? 9 days delay. So what is the date of accident? Twenty. Yes. Date of complaint. So 9 days after the incident. It's on 2/6/2014. Was a complaint. What was the explanation for the delay in giving the complaint? They were in. So the medical record was not marked MLC resistant. Let us just see the list of documents. Please come to that.
Document.
The intimation is there.
Vehicle.
Let us see. Let us read the order. Which para?
11 onwards, the pending was given.
Please read.
Five.
So immediately after the accident, when he went to the hospital authorities have given an intimation to the police. Because nobody has come forward from the claimant side, he has not. So that in that case, why would the delay will come into picture?
They have not lodged a complaint with the police station. There are two more lodged a complaint. Either they have intimated the doctor, but in the accident, then they will intimate.
That is done in this.
That may not, the vehicle number is not given. Vehicle number which is caused the accident is not mentioned. Subsequently, they have lodged a complaint where the vehicle number has been mentioned. That is after 9 days, they have lodged a complaint with mentioning the vehicle number. That's the reason they are giving the
Charge sheet is filed.
That's what Marat, the charge clearly because of charge sheet filed. It is not the conclusive proof to say that vehicle is involved in the pollution, active pollution of the owner. Necessarily, the charge sheet will file against you as a booking. It is the duty of the insurance the active pollution. Therefore, that there is a delay in charge sheet. Is where they have lodging the complaint, let us recognize the evidence record should be loaded in by the That's
No,
kind
in any MLC, when they give a statement to the doctor immediately after they admit in the hospital, what would they say? You know, like I met with an accident, so and so vehicle hit her. But they will not say the vehicle number. They, no, so what are the injuries sustained by him?
Your lordship, kindly, I will treat the admission as well as PW4 says that he is the eyewitness to the accident before he has intimated with the police. It's not correct. What the observation?
Come to para 13 and read that Kannada portion.
Nine and 13.
Read.
ಮಗಳಿಗೆ ಆದ ಅಪಘಾತವನ್ನು
Who is not the eyewitness? PW1 is father. Yes.
ಮಗಳಿಗೆ ಅಪಘಾತ ಮಾಡಲಿಕ್ಕೆ ಹೇಳುವ ವಾಹನದ ನಂಬರ್ vehicle number of the motorcycle number on the date of accident itself. But ಅಪಘಾತ ಆಸ್ಪತ್ರೆ ಚಿಕಿತ್ಸೆ ಅಪಘಾತವಾದ ದಿನಾಂಕದಿಂದ ಆಸ್ಪತ್ರೆ ಚಿಕಿತ್ಸೆ ಪಡೆದು ಬಿಡುಗಡೆ ಬರುವವರೆಗೂ he has not attempted any attempt to intimate the police regarding the vehicle number and plan the complaint. He has not any attempt. Discharge from the hospital. The accident, he has seen the vehicle in front of him. Never.
You are to the appellant in there. Yes.
Was past the accident. He said, I was not.
Let's hear him. Yes.
The entire inspection has been staged, saying that there is a contradictory statement. The discussion starts from the end of the judgment.
Yes. I've seen till para number this 13. Now PW4 is the eyewitness. The statement of PW4.
Investigating officer. He also.
Who PW? Oh.
Investigating officer. Given statement before the court saying that this vehicle involved in the accident. I have produced all the police documents, including the charge sheet, established.
Please come to para number 16 and read what is evidence of the investigating officer.
Whereafter the cross. Gayatri missing over the bridge. ಬಂದಿರೋ ಇಲ್ಲೋ ಎನ್ನುವ ಬಗ್ಗೆ ನನಗೆ ಈಗ ನಿಖರವಾಗಿ says that he has received the intimation from the hospital regarding the accident. He received or not the intimation. ನನ್ನ ಪ್ರಕಾರ MLC ಮಾಹಿತಿ says has received the intimation same day of accident. Again, he says being that received the intimation. ದಿನಾಂಕ 23/5/2014 ಭೇಟಿ ನೀಡಿದ್ದು ಆ ವೇಳೆಗೆ ಭಾಗಿಯಾದ ದಿನಾಂಕ 23/5/2014 ಭೇಟಿ ನೀಡಿ ವೈದ್ಯಾಧಿಕಾರಿಗಳನ್ನು ವಿಚಾರಿಸಿ ನಾನೇ registered the case. ದೇವೇಂದ್ರಪ್ಪ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ ಎಂದು ಹೇಳಿದ ಬೈಕ್ ನಂಬರ್ ಅದೇ ಬಗ್ಗೆ ತನಿಖೆಯಲ್ಲಿ ದಿನಾಂಕ 23/5/2014
The crux of the issue. Now, how PW1 came to know about the number of the vehicle? He is not a eyewitness to the incident.
Eyewitness is PW4. He has given the number. He has given the number. On the basis of that only the case has been resisted. Investigation. Seat also is. Yes. In fact,
What was it then on compensation? Any exercise was done?
compensation like 56.
No, any exercise is done on that. Hmm.
PW5, but on perusal of the evidence of PW5, it appears that the everyone made not compared to the above evidence is that it is a five. The above that says that man, he has seen the vehicle, he has not made any attempt to lodge the complaint. One evidence he has given. Another part he says that not he has seen the vehicle in front of the station. PW5 stated that the PW4 stated that he has given the statement before the PW5 on the same day, but police complaint was lodged on 26. They contradictory evidence indicate that the vehicle has been implanted, including the owner of the vehicle.
Exhibit R1 is the emergency.
No, there is no dispute about the road accident. Dispute is about the involvement of which vehicle. Take that. Your mere delay in lodging the complaint itself cannot be a ground, but the court has also has to examine. Yes. No, because you say that you went to the police or the vehicle before the police station, you went there till the police station. You don't choose to give the complaint. The evidence of PW4, PW5 is there is no consistency between 1, 4, and 5. That gives any amount of doubt.
Where are the witnesses? Yeah,
And what are the injuries sustained by him, for which you couldn't give the complaint for 9 days?
this was in the hospital only.
What are the injuries?
Taking this, it was taking.
What are the injuries?
He undergone station.
Give the lower court record. When is the charge sheet is marked as
It is
E6. What did they say in the charge sheet? How they came? What did they say in the charge sheet? Charge sheet. Hmm. 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 The one which you are passed on now. Hmm. Hmm. Hmm.
Firstly, the appellant said. The accident. That million driving. Secondly, the appellant made material documents the factor of the accident, the persons involved therein. Thirdly, the documents clearly established the identity of more documents should be filed. First, insurance against. If the, so far as the insurance company is concerned.
Who is PW4?
What is the eyewitness? He is the eyewitness. PW5 is the investigating authority. He thoroughly investigated the matter. In fact, the PW visited the hospital.
There is some other judgment on that they need not challenge the charge.
The owner is with the insurance company. They could have.
The whole case is the owner is in collusion with the claimant. Why would they hear what they advise? Owner of the vehicle said the vehicle is involved and
He has given. The absence. Section has to be.
the appeal filed for the claimant appealed with the award passing release number 2/7/2014 dated 18 September 2000. Claim petition is specially compensates of an amount of 8 lakhs for injuries sustained by the claimant in the motor vehicle accident. With the case of the claimant that on 23/5/2015, about 4:15 p.m. The claimant is proceeding in the side of the road. Nagara Bavi main road. And when she reached near the rental clinic, at that time, the rider of the motorbike rode the same in a rash and negligent manner and dashed at the petitioner. As a result of the said accident, the petitioner fell down and sustained serious injuries. Thereafter, she was shifted to the Gayatri Hospital, Bangalore, where she had taken treatment as an inpatient. She was aged about 15 years, studying in 10th standard. Because of the injuries, she is not able to lead a normal life. It's a case of the insurance company before the court below that in collusion with the owner of the vehicle, the said vehicle, the number of the said vehicle is implicated in the case. It is stated that at the earliest point of time, when the MLC was referred to the in the register, though it is mentioned that the accident has occurred, the injuries were sustained in a road accident, the number of the vehicle was not mentioned. The accident has taken place on 23/5/2014, and the complaint is given by the father of the complainant on 2/6/2014. There is a delay of 9 days in giving the complaint. No explanation was given after 9 days. The court below, and accordingly, the period report to this, that the vehicle is not involved. The insurance company is not liable to pay the compensation. The court below, while deciding the said issue, had observed that on a perusal of the evidence of PW1, 4, and 5, the PW1 was a father of the claimant, is not an eyewitness to the incident. On the other hand, he himself has admitted in the cross-examination that on the next date of the accident, he has seen the offending vehicle in the police station. On the court further observed that on perusal of evidence of the PW4, it appears that on the date of the alleged incident, that is on 23/5/2014 itself, PW4 has given statement before PW5. But on perusal of the evidence of PW5, it appears that on 2/6/2014, PW1 went to the police station and lodged a complaint before him. Considering the evidence, the court below comes to the conclusion that there is an inconsistent evidence of PW1, 4, and 5. If at all the alleged incident has occurred as contended in the petition, then there was no hurdle for the father of the petitioner to lodge a complaint before the police on the same day or next day of incident. Further, the version of PW1 is that on 23/5/2014 itself, he has received the MLC intimation from the concerned hospital. Court, considering the evidence of PW1 about seeing the offending vehicle in the police station, evidence of PW5, who has received the intimation on 23/5/2014, and a case was not registered till 2/6/2014. The evidence of PW4, who says that on 23/5/2014 itself, he has given the statement about the police. Considering all the discrepancies in the evidence, the court has disbelieved the version of the claimant that the offending vehicle is involved in the accident and dismissed the claim petition. Then counsel appearing to the appellant submits that there is no dispute about the fact that the incident had taken place. As at the earliest point of time, in the register, it is mentioned that the vehicle is involved in the accident. The claimant has sustained injuries in a road accident. He submits that the PW4 is an eyewitness who gave the statement to the police immediately, and in spite of an MLC, the respondents and the PW5 has not registered the complaint. He submits that as the claimant was in hospital and she has sustained grievous injuries, the father he couldn't give the complaint immediately. That itself cannot be a reason to disentitle the claimant from claiming compensation. And the court below has, without appreciating the evidence and the material on record, has dismissed the petition. He has also relied on the judgment of the apex court in Vimla Devi and others versus National Insurance Company Limited and another, reported in 2019 to SCC 186, and submits that. And he relied on para 20 of the said judgment, which reads thus, extract from para 20, that is 20 to 20.8. Basing on this, it is submitted that the tribunal went wrong in discussing the main petition more on technicalities. When counsel appearing for the insurance company submits that the court below has rightly considered the evidence of PW 1, 4, and 5, which is inconsistent. And looking at the delay of 9 days in giving the complaint, which shows that the vehicle, the collusion between the owner of the vehicle and the claimant, the said vehicle implicated in this case. He submits that the owner of the vehicle has conveniently remained ex parte before the court below, who had given a statement before the police, a 166 statement. He has given a statement, given a statement for the police, has conveniently remained absent, which clearly demonstrates that there is a collusion between the claimant and the owner of the vehicle. He submits that the court below as rightly is the claim petition. In this case, in respect whether the claimant has sustained injuries in the road accident, there is no dispute about the said fact, as immediately after the accident, when she was admitted in the hospital, in the MLC register, it is mentioned that injuries were sustained in a road accident, and they have informed the same to PW5. PW5, having received the same, has kept quiet. And in the said communication, the number of the vehicle's number of the offending vehicle is not mentioned. It is a case of PW4 that he gave the statement to the police on 23/5/2014. And it's the evidence of PW5 that no complaint is given by PW4 on 23/5, and the complaint is given by PW1 on 2/6/2014. According to PW1, he has seen the offending vehicle before the police station the next day. It is not the case that he was not in a position to come to the police station, as he was very much in hospital. He couldn't give the complaint. When he came to the police station and found the vehicle outside the police station, nothing has prevented him to give complaint to the police. Every delay in giving the complaint cannot be fatal to the case of the complaint, but the court has to evaluate the same basing on the facts and circumstances of the case. In this case, the delay in giving the complaint in this case goes to the root of the matter, and the inconsistent evidence of PW1, PW4 and 5 all the more supports the case of the insurance company. In the facts of this case, the judgment relied on by the learned counsel for the appellant is not applicable and applicable in view of the board discussion. This court finds no reason to entertain this appeal. Accordingly, appeal is dismissed. Yes.
Your lordship's plea, my lord.
Yes,
41.
Serial number 38, my lord, I was in the other court.
there was no, it is submitted that counsel for the appellant is unwell.
Urgent, my lord.
After 2 weeks.
Please.
Yeah. 41 and 41 point, yeah. Claim petition, how much was the claim? How much was granted? 1 lakh? Any disability? Let's see the first issue, Mr. Liability, yes. Let's see. Yeah, let's read which para. No, like, why can't we go to issue number 1 and 2 at page number, para number 10? Yes. What did you must have filed a written statement before the court below. What did you say that there is no policy? And what was the finding of the court on that? How can it be? Give the file. Lower court record. You have a copy of your statement. As per the records of company has issued a cover note of that number to a two-wheeler vehicle. What is the vehicle here? At Maharashtra, and they have filed a cover note, not the policy.
They have not known. That's what we learned. They have not mentioned anything.
So that's the issue which has to be decided by the court.
That's the reason.
No, you claim the compensation from the insurer and owner of the lorry. So first of all, lorry should have insurance. Who insured it? Where is the insurance policy? Those are all the issues. Right. How the court has decided that? So they have taken a plea that you are relying on some cover note or something which they have issued for a vehicle in Maharashtra, which is a two-wheeler. And that also expired. So the first is, you should take, no, you should say that to whom with it is insured, what is the policy? Huh? You are third party. Now, even to a third party, if the insurance company has to pay, there should be a contract of insurance between the two. That's that's the crucial aspect. Where is it now? They took a stand in the written statement. Where was it dealt with by the court? Who? That's the for fastening the liability on them. That's the issue to be decided first. That because this vehicle is insured by so and so, and as because of the rash and negligent driving of the driver of the offending vehicle, the accident has happened. They are able to pay the compensation. Should be the finding. We'll remand the matter.
They produce the policy here also, I will admit.
No, let them, because then again, once the evidence has to be let in, they want to examine, or you want.
Then,
We'll remand the matter.
if they provide the policy number, I will explain and admit the ladies from the law.
Ultimately, if we go. Any? You want to ascertain the policy number? It won't, on the face of it, it has to be dismissed. Giving you an opportunity, I'm remanding it. Agreed by the award passed in MBC number 344 of 2012, dated 13th February 2015. Both the insurance company as well as the claimants are before this court. The appeal of the insurance company is numbered as MFN. Your appeal is? No, number. Is your appeal. Claimant's appeal is numbered as MFA number 1921 of 2016, and the insurance company's appeal is numbered as MFA number 2473 of 2016. The insurance company is questioning the liability, whereas the claimant filed the appeal seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs, and the court below has granted an amount of rupees 1,22,630. It's a case of the claimant that on 25/12/2011 at about 11:10 p.m., the claimant was proceeding in his car, driven by himself, when the said car reached near Gangoli police station on NS 66, Osadu village, Undapara Taluk. At that time, a lorry belonging to the first respondent, driven by its driver in a high speed and negligent manner, came from the Sase side towards Undapura side and dashed to the petitioner's car. Due to the said impact, petitioner sustained grievous injuries, and he spent lot of amounts towards the treatment. The respondent insurance company has filed their counter before the court, stating that the respondent has not received any premium with regard to the paid cover note. As per the records, the company has issued cover note of that number to a two-wheeler vehicle at Maharashtra. The cover note was expired due to non-payment of premium, and the insurance company is not liable to pay the compensation. They've also taken the plea that the driver of the, you take all inconsistent pleas. When you yourself say that there is no policy, how are you bothered about that?
This is only intimation given by them, we have given.
Insurance company is not able to pay the compensation. The court below on the issue of liability where it said that you are liable to pay the compensation. First respondent is who? First respondent is owner of the vehicle. It mentions about only first respondent, no discussion about. Where do you get? Hmm. 20 para 21.
One is the
What did you say? Quote below.
Issue of liability.
The quote below on the issue of liability, without any discussion, without even considering the defense taken by the insurance company that they have not insured the vehicle, without there being an insurance policy on record, has held that the vehicle is insured with the insurance company and the insurance company is liable to pay the compensation. Then counsel appearing for the insurance company submits that when it is a specific plea that they have not insured the vehicle, and when they have clearly stated that the cover note was issued in respect of a two-wheeler and the respondents, the court below has fastened the liability on the insurance company. Land counsel appearing to the claimant submits that submits that though it is stated that the cover note is issued for a two-wheeler, no such cover note was not produced before the court. The same was not marked. It is submitted that without examining anyone, without producing the said cover note, the respondents cannot deny the liability. It is submitted that the court below has rightly held that the insurance company is liable to pay the compensation. Then counsel submits that as far as the quantum of the compensation is concerned, the company has failed to, the court below has failed to consider, has not granted the compensation. And the compensation that is granted is not just and reasonable. The next paragraph. The insurance company has filed the written statement. They have taken a specific plea that the vehicle is not insured with the vehicle is not insured with them. And when they even a cover note which is mentioned, it is stated that the cover note is issued in respect of a two-wheeler in the state of Maharashtra. In such case, the tribunal, without any discussion, without any finding, has straight away given a finding that the offending vehicle is insured with the respondent insurance company. Both the claimant and the insurance company have not adduced any evidence before the court below. In that view of the matter, and in the interest of justice, the court deems it appropriate to set aside the order under appeal and remand the matter for fresh consideration before the court below. Accordingly, the award dated 13th February 2005 in MVC number 344 of 2012 is set aside. The matter is remanded back to the trial court. Both the parties if the two, can reduce the evidence in this regard, and the court below shall decide the appeal within a period of decide the petition within a period of 2 months from the date of receipt of the copy of the order. Without further notice from the court, the parties shall appear before the tribunal on when September 21st. On September 21st. The registry will transfer the loan for records immediately. So, the amount that is deposited by the insurance company shall also be transmitted to the court. It has to be decided, let it be. That's what I mean, and shall be kept in the fixed deposit. It will be transmitted to the court below. It shall be kept in the fixed deposit. Yes.
Serial number 42, Shivkumar, please.
This case appearing for appellant, my lords.
Yes.
My lords, ready, my lords. 230, my lords. Kindly pass over the matter for 230.
No, the entire list is on password today.
Senior is in other court, my lords.
Passover 42.
Please, ma'am.
For the respondents.
You appear to the appellant. Should the file. What the court has said, any pay and recover is ordered. No. Is there, Mr. Maheshwari? Then we'll pass over this matter, let him come in, after if it is only violation of permit conditions, we'll order pay and recover. That will do. Yes, sir. Yes. Yes, Mr. Venkatesh, you're ready?
I am appearing for the appellant insurance company, my lord.
Hmm.
This is appeal on quantum and negligence, my lord. 33% negligence on me is bad anta I have questioned before this court, my lord, including quantum.
Oh, both appeals are there.
No, I have filed only one appeal, my lord. Other person is Mr. Rajsekhar filed for
He's here. He's here.
Oh, sorry, my lord.
What was the claim? How much was awarded? $10,39,000. What was how the contributory negligence is apportioned? What are the vehicles involved? Car, lorry, and which vehicle is insured by them? By Mr. Venkatesh?
My lord, I have insured 5505 car, my lord. United India Insurance.
50?
5505. That I have issued, my lord.
No, it is
And-
apportioned as, how it is, the contributory negligence on you, how much?
33%, my lord.
33%.
Yes, my lord.
Let's see.
Kindly come to page number 9, para number 12, my.
Yes,
Shall I read, my lordship?
yes, please read.
The PWN has filed her affidavit on oath on examination in chief, wherein she deposed in accordance with the contents of the petition. Perused the cross-examination of the said witness. The said witness was cross-examined by London Council for PKS appearing for response number 3. She stated in her cross-exam that she is not direct witness to the accident. She cannot say registration number of the vehicles involved in the accident. She further deposed deceased Akram overtook the lorry and took his vehicle ahead of the lorry with competition. She further stated driver of the lorry has drove the vehicle in a negligent manner, hit the backside of the vehicle being driven by Akram and caused the accident. Next para, my lord. The said witness was also cross-examined by Sri so-and-so, advocate appearing for respondent 6, wherein she denied citation of the driver of the car 18 and 52 had drove in a rash and negligent manner to overtook the lorry so-and-so, hit against the car which she was coming from the opposite direction. She further stated that after the accident, lorry had come and hit against the car in which her husband was traveling. Then come to page 11, para 17, my lord. On careful analysis of evidence of PW1, RW1, RW2, which reveals that there is no dispute regarding involvement of 3 vehicles. It is pertinent to note that no reliable and appropriate evidence produced by RW1 and 2 to prove the accident was not because of rash negligence Tata Indigo Manza car 5505, which was insured with me, my lord. No doubt, their evidence is that because unhealthy competition between Maruti Swift car and lorry accident has occurred. This piece of evidence of defense is against the charge sheet filed by the investigating officer. The charge sheet is exhibit marked P4. It is also pertinent to note that on 19/5/16, the Learned Council petition has filed a memo along with the charge sheet for disposal of this petition and remaining Supreme Court cases. Then, my lord, I will take my lords to page 14, para 22.
Yes.
It is clear from the reasons assigned on issue number 1 that all 3 vehicles were equally contributed to the fatal accident. Accordingly, petitioners have suffered for reduction of compensation proportionate to their quantum of negligence contributed by deceased Akram, who is the driver of Maruti Swift, in which deceased Mahantesh, who was husband of the petition number 1, was traveling. On the other hand, respondent 1 to 6 are jointly severally liable to pay the compensation petition proportionate to the negligence contributed by the driver of Tata Indigo and lorry. As per the materials, Tata Indigo Manja car duly insured with respondent number 3. Lorry is duly insured with respondent. In other words, 3 and 6 are above said vehicles respectively. Next, come to para 24, page 15, my lord, the final apportionment.
Yes.
Out of total compensation 1039, 33% of it is deducted towards contributing to the vehicle in which deceased Mahantesh was traveling. After deduction, so also. Thus, the total of 1 and 2 are entitled compensation 696,130 with interest at 6% from the respondent 1 to 6, who are jointly and several liable to pay it. Initial respondent of payment of compensation is fixed on respondent number 3 and respondent number 6, who are the insurers Tata Indigo, Manja, and lorry bearing so and so, respectively. Question of fixation of response and respondent 7 does not arise because towards contributory against 33% compensation is deducted. This is how the finding is apportioned by the learned member, my lord, and evidence may also be looked into, my lord. Cross-examination of PW1 or the claimants may kindly be taken up, my lordship.
He was, the deceased was unmarried. So you are on what ground, Mr. Venkatesh?
Yes, my lord.
You are on what ground?
33% fastened on me is wrong. And that is only the question before this court, my
How
lord.
much should be fastened on you?
No, my lord, my lord, the car has crossed the median line and dashed to my car. It is between lorry, there is a competition between lorry and the car. So he has crossed the median and dashed to my car, which I am nowhere responsible for 33%, my lord.
You are coming from the opposite side. This vehicle is coming from the opposite side.
Yes, my lord.
And this vehicle crossed the median and
Crossed the median and dashed to overtake the lorry and dashed my car. So both lorry and the car are the responsible, not my car.
You are the insurer for the car,
I am
lorry.
the insurer of the lorry.
This what do you say?
Please, they have the other positions. Simply I filed all of this case. Just collect with my friend, my lord's judgment copy I have, not the positions I don't have.
The court has already read the whole case. Now again adjourning again, the same exercise has to be done the other day. On the face of it, it appears that fixing contributory negligence on that car is bad.
So I am convinced because the car in which the deceased was traveling, my lords, has overtaken my vehicle and my lords in the high speed has gone ahead and the accident has taken in the middle of the road. My lorry is proceeding, my lords, in a moderate speed. My lords, because of the accident, my lords, I could not have any time to, my lords, gauge whether, my lords, I cannot, my lords, apprehend that, my lords, there will be an accident. Once I have gone in my speed, my lords, because of the accident, my lords, I have gone in it from the inside. Once in this scenario, my lords, there are judgments to the effect to say that, but if I don't have any, my lords, time to navigate or apply my brake to stop my vehicle, therefore, not negligence would be only on the part of the monarchs, the deceased on which he was traveling, not is the monarch's proposition of law. This is not it.
Private car. You are inmate of the car. Then what happened to the driver? That is it. That is not along with this. Then where is your contributory negligence on his part? He's not the driver of the vehicle.
It should be him, my lord.
He's an inmate of the vehicle.
Yes. Therefore,
Then the insurer of his car
marks would be liable.
was not a party.
He's not, I don't know whether he has not insurance policy for his car.
No, there is a judgment of the Supreme Court that in the case of composite negligence, you can claim at any one of the tortfeasors also. But the issue here is, are they the tortfeasors or not is the question.
Yes.
If it is it's not, if it is because of the negligence of the driver of the car in which you are traveling, the accident taken place, then you necessarily have to implement that you have to claim compensation against the insurer of that vehicle. It's not that, no, from the report, from whatever now the report has seen, it is not alone, it's not a case of contributory negligence. It is stated, but it is exclusively because of your negligence. There is no contribution from their side. When you post on Monday for judgment,
Please, my lord.
third learned counsel for the appellant and respondent post the judgment on Monday.
Please.
Yes,
Bill number 46, is there Prasad Kesi?
40. You appear in 46. Yes. Yes. After lunch to take. After lunch, a big list of passwords there.
I'm not having tomorrow, particularly at 2:30, but then I'll make myself.
Or else I'll take up this as a continuation matter. All this was not.
Mine's serial number 49. I am ready, but whether any possibility of reaching or not, I am ready. 49.
When
But-
item number 46 is going on, why do you tell the court that you are ready in 49?
Because evening session, if there is no possibility of reaching, tomorrow it may be.
Court officer, sir. Court officer, sir. Court officer, sir.
Yes, sir, ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಟೈಮ್ ಹೋಗಿದೆಯಾ ಮೇಡಮ್? ಅರ್ಜನ್ ಆಗಿದೆಯಾ ಇಲ್ಲ ಇದೆಯಾ ಮೇಡಮ್?
47 ಇದೆ.
47
ಫಾಸ್ಟ್ ಓವರ್ ಆದ್ಮೇಲೆ ಕರಿತಿದೀವಿ ಅದನ್ನ.
ಅರ್ಜನ್ ಏನಾಗಿಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್ ಅದು?
ಇಲ್ಲ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಡಬಾಲಿ ಅವ್ರು ಇಲ್ಲೇ ಇದ್ದಾರೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Yes. EFA for the respondent. Huh? Hmm. Hmm. Yes. Hmm. Yes. Of course, the have the facts. Claim was for 4,53,000 and 1,50,000 towards medicines. He was working as a.
He was working under a contract.
Hmm. Hmm.
For
Hmm.
their maintenance of service.
Hmm. 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 Hmm.
10 to 2010,
Hmm.
he happened to,
Yes.
he was injured. Climbing.
You're liable to pay the. Let us go to the particular finding of the tribunals on your liability. Hmm.
Whether the applicant proves he was working as an electrician with the recommend of the law, as not the the applicant proves he is entitled for compensation, sir. Make note.
No, why the court says, before going into the merits of the case, there is no dispute of employee-employer relationship between the petitioner, second respondent, and also first respondent as a principal employer. No, the court starts with, according to you, it's a dispute. According to the court, it's an admitted fact.
According to the court, it's an
Hmm.
not according to the
Hmm.
the,
Hmm. Hmm. Is the record. This is the exhibit. Agreement you are referring to. On your behalf, R1 to R4 are marked. R1 is authorization, R2 is agreement. R2A is agreement page number 78. Next is connection. R2. Give R2. Exhibit R2 is 22nd Jan 2009. Schedule of what planning and operations. In the where do you get that with serial number? General conditions of contract is serial number 5. General conditions of contract. Contract of so and so. It says the 73 of 2008 or 2009 something. No, from the lower court record. What it reads? Is this the one? Okay. Is it page 13? Page number 22. Page number 13. Manning and operation of certain installations. Page number 75. Yes.
Okay. 11 months.
Hmm.
For those provisions, only the partial for the all the things they follow the technique. So the information
Now you're referring to after 78? 79. Hmm.
in my contractor will ensure that safety measures
Hmm. Defined under two.
scheme.
Yes.
Employer includes any body of person, whether incorporated or not. Working. And it requires liability. If person injury is caused to the employee by an accident, that is the cause of the employee. Employer simply liable. Section 12.
Yes.
executed by I employed in the execution of work and a compensation would have been liable to pay if that employee had been previously employed by him and the compensation is meant for the actual apply with reference to the principle that substituted for the reference to the employer except that the amount of is not 500 employee.
That's the crux of the issue.
Unable to evict the from he was my employee the executive of the work. This work is that any work which is one
Yes, I've seen.
the first that we got. The second find the contention of employee it is not part of and not
But the same on section 11 of that. Judgment is also on section 11 and 12 of the Act and the interpretation. Yes. Anything else? Yes, Mr. What do you say? You appear for the contractor. As for the terms of the contract, you are solely responsible for any of the compensation that has to be paid to the employee. Is it not? You was working? You paid the? Yes. No, before going into those details, let's have the facts clear. Now, he has shown the certain clauses of the general conditions of the agreement. Everything, first issue, whether he employed that workman or you have employed, is working under him or under you. Where is that correspondence or any communication? What is marked? Not about the complaint, it's not about the assertion. It's about from which material. Yes, Mr. What is that? When there is a question of you paying, when he is a contractor, you will be paying to the contractor. Contractor in turn will pay to them. So what from which exhibit you are saying that salary is being paid by him to the all the employees? Let us see the exhibits marked on your behalf. FAR, complaint, Mahajar, charge sheet, wound certificate, medical bills, discharge summary, case file. No, let's not go into that. First issue is, according to you, though you have employed him, but he was directly working under the principal again with him, and he is directly paying the salary, but not you. Where from that has to be that? No. It's from the material we have to find out, from the evidence. So once that is not there, then what is there before the court is agreement and the terms of the agreement. As per that, you are solely responsible for any compensation for any of the claims arising out of the employment. Then we have to rely on the particular conditions in the agreement. Yes. Page number 8. Para number? Yes. No, for this, where is a material for the court below to come to such conclusion? That directly under his instruction. Who said that some statement made by, because then that is contrary to what is the agreement which is marked contract. They proceeded more on assumptions and presumptions rather than looking at the material on the cost. No, it's a twofold. It's the 12 is twofold. The court is elaborately discussed in these judgments also. Not this judgment, the other judgment, first judgment applies. No, let's read 12. Hmm.
Any compensation which is likely to pay the workman that he immediately employed. Compensation is there.
What will happen to the contract? What will happen to the contract which you have entered? Contract. No, no, again, we don't mix this issue with that. No, you're relying on 12. And there is a contract between you and the principal. And as per that, all compensation, whatever is arising in the course of employment has to be paid by you. That's what is a contract. For that, you have to adduce the evidence. We just court cannot, basing on without any evidence, court cannot come to that conclusion. What is the evidence of the claimant? What is the evidence of the claimant? Is examined as? He says that I'm working with the first respondent as electrician. Petition himself, claimant himself says. No, he's working as an electrician. Just now you're saying that he's a casual labor. He is not well versed with all this, and at the behest of the employer, he has claimed, and you're only the contractor is responsible. Please come. Come. No, it's not only humanitarian grounds. You're also bound to. No, you're bound to as per the contract. Huh? The agreed whether what passed in ECA number 170 of 2014, dated 30th December 2016. The present appeal is filed by the first respondent in the that is represented by an advocate. How the court will presume that he is not available and who had given him instructions to appear. Hmm. He's still with you. All his payments are cleared.
It's gone out, Melanie.
Problem is, we can do something legally, and on a humanitarian ground, if something is permissible within the permissible limits, we can do it. Because you can't recover from him. So the court cannot say though they are not liable to pay and recover from him.
Respondent, he fell in fall, fell down, say 26.
Yes, the first respondent has preferred the present appeal. The claim petition, the petition is filed under section 22 of the Workmen Compensation Act, seeking compensation of an amount of rupees 4,53,000 as compensation and an amount of rupees 1,50,000 towards medicine. The case of the claimant was that he was working with the first respondent as an electrician since June 13, 2009. On being appointed to the contractor, that is the second respondent. The second respondent has inducted the claim petitioner with the claimant without any appointment letter or written communication. While he was working with the first respondent from 13/6/2019. He was drawing monthly salary of rupees 3,500. On 10/2/2010, on the instructions of the first respondent, he attended the lightning problem over one of the electric poles inside the premises of first respondent. At 9:15 p.m., when he climbed the top of the electric pole to rectify the circuit problem, and while doing so, he came under the electric shock and fell down from a height of about 20 feet, sustaining grievous injuries, including injury to head. He was shifted to the Army Hospital, from where he was shifted to the Lady Bori Hospital, where CT scan was done, and thereafter he was shifted to St. John's Medical College, wherein he had undergone treatment till 7/4/2010. The disability was assessed at 58%. Both the first respondent and the second respondent, the principal employer and the contractor, have filed their objections. According to the contractor, he was working. The petitioner was working with though he has employed him, he's working on the instructions of the first respondent, principal employee, and at his instructions, he climbed the pole and got injured. He submitted that as per. It is the case that as per section 12 of the Workmen Compensation Act, the principal employer is liable to pay the compensation. It is a case of the principal employer, as the first respondent, that as per the contract, any compensation has to be paid by the contractor, and in view of the same, as the workman was employed by the contractor, they have no liability to pay compensation whatsoever. The court below basing on behalf of the workman, PW1 and PW, himself examined as PW1. PW2, doctor was examined. Exhibit P1 to P8 were marked. On behalf of the respondents, RW1 and 2 were examined. Exhibit R1 to R4 were marked. The court below, looking at the evidence of the contractor, the oral evidence of the contractor, as well as the workman, observes that it is crystal clear from the pleadings of the parties that the petitioner was working with the first respondent by being appointed through contractor, the second respondent. The second respondent had inducted the petitioner with respondent number 1 on monthly salary of rupees 3,500. And further, observe that as an incident has happened when the petitioner was working on the pole on the instructions of the first respondent, the oral evidence of RW1 and 2 do not inspire confidence in the mind of the court. Hence held that the respondent number 1 alone is liable to pay the compensation. It is the case of the claimant, the court below has also observed that towards the medical expenses, an amount of rupees, where do you get that? Which para of the order? Para number 17. You have spent that much? When you were saying about the contractor has spent an amount of 88,000. 88,975 towards the. So that's a compensation. So where is observation by the court? No, where is the finding of the court that you have spent that much amount? It is the case of the contractor that for all the medical bills were taken care of by him on humanitarian grounds, and he is not liable to pay the compensation. Accordingly, the court has allowed the petition granting compensation of rupees 4,02,088. No, granting compensation of 5,91,063. Learned counsel, the Deputy Solicitor General, appearing on behalf of the appellant, submits that has drawn the attention of this court to exhibit R2 agreement. Exhibit R2 is the agreement between the first respondent, between the appellant and the contractor, dated 22nd Jan 2009. Exhibit R2, R2A is a exhibit R2 is agreement, and R2A is a particular specification of agreement at page number 78. which deals with the particular specifications for executing the work as per clause number 9.4. 9.4 extractor 9.4 serial page number 78. In the R2B is the agreement page number 79. As per clause 11E of the terms and conditions, the contractor will, within inverted comma, the contractor will ensure that proper safety security measures are taken by his operators or his staff for safe custody of installed equipment, etc. And he should be entirely responsible for any accident occurring at the installation. The department will not be responsible in any way for any compensation whatsoever. And 12.5 specifies that the operation within the operation personnel shall have thorough knowledge of safety precautions during emergency cases and also be conversant with Indian electricity rules, regulations, and Indian Factory Act rules as applicable on installations which fall under the purview of the contract. Then council submits that the code below, without looking at any of the without looking at the exhibits marked on behalf of the respondents, that is exhibit R1 to R2B, has come to a conclusion that the principal employer is liable to pay the compensation. The code below has not even gone through the terms and conditions of the agreement between the parties, which clearly demonstrates that the contractor alone is responsible for all the claims. The Land Council has drawn the attention of the court to the definition of employer. Section 2E of the Act defines who is an employer, which reads thus: extract that employer. Also, it is submitted that only the employer has a liability for paying the compensation. Then he has drawn the attention of the court to Section 12, which deals with contracting. Extract 12.1 and 12.2. He has relied on the judgment of this court in case of divisional manager, Southern Railway, Mysore versus Chandni Bay. What is the citation for this? Where is this reported? Dated 28th November 2006. Relying on para number 16 of the said judgment. What is it? ACJ? Reported in ACJ 2007 or else AR Karnataka 2007, 352. Para 16, 17, 18. And also relied on another judgment of this court in Bharat Earth Movers Limited, judgment of the division bench in Bharat Earth Movers Limited and Bhagyama and another. Para number, extract para number 9. He has relied on another judgment of the High Court of Madras. In case of K. Venkat Raman, R. Raman Lal, reported in Laws Madras 2009, 7/6/37, dated June 21, 2006. Which para of this? Para 5 and para 9. Submits that only the contractor is liable to pay the compensation. The court below, without appreciating the agreement and the settled law, has held that the appellant is liable to pay the compensation. Then counsel appearing for the contractor submits that he was examined as RW1. He was examined as RW1 and the RW2, and the claimant the workman was examined as PW1. The evidence of PW1 as well as RW2 is consistent that the principal he is working under the principal employer. That's the appellant here. In the evidence he has deposed that the workman was not competent to was not an electrician. That's what you said. Was not an electrician. Where you are acquitted. He deposed before the court that he has not employed the workman. He has employed the workman for a mechanical work, but not for the electric work. For plumbing and mechanical work, but not for electrical work. At the behest of the principal employer, he has climbed the pole and he sustained injuries in the said accident. It is submitted that when a criminal case is filed against the principal employer as well as a contractor, he was acquitted by the criminal court. In that there is an observation by the court that the evidence reveals that the workman was not employed for the purpose for the electrical works, but for the purpose of mechanical and plumbing works. Basing on this, he submits that as per section 12 of the Act, it's only the principal employer who is liable to pay the compensation. It is submitted that though he is not liable to pay the compensation on humanitarian grounds, he has paid the medical bills. to the tune of 4,61,555. 61,555. Learned counsel appearing for the claimant submits that he was as per that he is an electrician. According to you, you are an electrician. You are appointed as an. Huh? No, that's what you say so in your affidavit. Chief affidavit. Chief affidavit, it is stated so that I am appointed as an electrician. According to the claimant is an electrician appointed by the contractor and is working with the first respondent, that is a appellant herein, who is the principal employer. He submits that he has sustained grievous injuries, and because of the injuries, is not in a position to work. It is stated that the appellant herein is liable to pay the compensation. The court below has rightly, basing on the evidence, has held that he is liable to pay the compensation. In this case, having heard the learned counsels on either side, this court had perused the entire material on record. A perusal of the judgment impugned, the court below, in the entire order, had failed to discuss anything about the exhibits R1 to R2P. The court, all through the judgment, had discussed about the evidence of PW1 and the evidence of RW2. When there is an agreement between the first respondent, when the first respondent and the second respondent have entered into an agreement, and as for the terms and conditions of the agreement, the contractor, that is the second respondent, is alone liable to pay the compensation as per this page number 78 and 79 clauses. As per the set clauses, the contractor alone is liable to pay the compensation. It is a case of both the claimant, both the workman as well as the contractor, that the principal employer is paying the amounts paying the salary to the workman, and at his instructions, he has climbed the pole and sustained the injury. In that regard, except the oral evidence of PW1 and RW2, there is no other evidence available on record. The court below, more on assumptions and presumptions, without looking into the entire evidence on record, has held that the contractor, the principal employer, that is the appellant herein, is liable to pay the compensation. This court, looking at having perused the agreement and the agreement between the parties in the light of exhibit R2, R2A and R2B, the contractor alone is liable to pay the compensation. In view of the same, the court below went wrong in coming to such conclusion. Accordingly, the appeal is allowed, and appeal is allowed, setting aside the order of the court below, as far as the liability of the first respondent, the appellant herein is concerned. The compensation that was awarded by the court below, the contractor, that is the second, which respondent you see? Second respondent here. The second respondent alone is liable to pay the compensation. Amounts that were deposited by the They shall be transmitted to the court below. There you can, no? The respondent insurance company, there is the appellant is at liberty to withdraw the deposited amount on the date 17/4. Yes. Call the password.
For dismissal,
We appear for the insurance company.
I am appearing for the appellate team, MFA 9510 of 2012.
Yes,
This is not connected with any case. My case needs to be decided independent.
no, please argue.
Kindly take the grounds of appeal which I have urged. It's very simple in consonance with requirement of section.
Item number 18, you are arguing.
Yes.
No, it's okay. We'll hear this matter. That's what I told on the last week. Yes,
Lord will kindly see,
yes.
take the claim petition first.
So you please give the details. Now, claim is for how much?
10,000 rupees per month is the salary claim. Which would come to 1,20,000 per annum.
The petition is filed under section 163A of the Act,
Yes.
seeking compensation of 15,28,000.
Yes.
Then what did the court do? The court, how much was granted?
2,100,000. Lord will kindly take to para 12 of the judgment in page 15 of my paper, appeal paper. Para 12, where the tribunal deals with the income aspect. May I read that?
No, you have filed an application under 163A.
I am in appeal. Insurer is in appeal.
Which appeal is, what is the number of your appeal?
MFA 9510 of 2012.
Wait, before that, there is 10448. The court is hearing that matter. I thought you were appearing in that.
No. That is the request I made at the first
We
instance.
will hear your matter. Yes.
No.
10448 you appear. Yes.
Kindly disconnect that case because it
How
is
many
not.
times it will be passed over?
My case may be disconnected from that.
We'll hear your matter independently.
Please.
Yes, what are the facts, Mr. Counsel? But this application is filed under 163A. So how much is the compensation granted? So it can be restricted to 40,000. Yes. Full bench of? No, some order, some view that is taken contrary to a full bench view. How is that, how can that be? Is it, isn't that law per curiam? Right? Which judgment is that of the Supreme Court? Deepak Girish Beswani is here. I think that day that was no, not any other judgment. If I remember, this judgment, there was a distinction made where with the old provision 144 or what? Where there they said was, for a, if I remember the last time I have seen this judgment, there the issue was simultaneously making an application under 163A for an ad hoc arrangement and then filing an application under 166. And the court said 163 is not as parametria with 144 or the earlier provision. Once you make an application under 163A, you cannot make it under 166. Yes, which para? No, not the conclusion. Before that, the discussion will see. Which para? Because there cannot be any problem because of their space. No, we will not go. Will not go to the any judgments of any other court. Please show to the court only the judgment of the apex court and any judgment of this court. Let's first go through this. No, Deepal, Girish Bhai, Soni and others. That we will see first. Court has referred to 141 and 142 of the earlier act. Please come to paragraph 52. Paragraph 52. Finally, para 57 is the answer. So 57 you read. No, independent of each other. So that was what the felt for consideration. No, please come to what was the issue. No, not the come to the starting. Please, subject matter. Please read that. Background factor. That is para number 5. The fact of the matter may be noticed. According to them, they were under the impression that it's an interim measure 163. That was answered, saying that that is answered at the para number 57.
That is otherwise not in the Supreme Court.
Next 59 also, para 59.
The question is on 67.
No, 59 we will read.
May be considered a different level. Therefore,
Yes, what do you say? So he is referring to a judgment of 2004 to that is of the Supreme Court. So latest judgment. And let's see. Please pass on. Because in the judgment, though in one line they said that you cannot have the cap that though your income is above 40,000, you can't have the cap and you can't claim it. That's one sentence. Where is this? No, this is a Karnataka High Court. How can the court take a view when there is a judgment of the No, I'll tell you, I'll just tell. There's only one line there. That is para 67, please read. 67 of the judgment. We therefore are of the opinion that Kodala has correctly been decided. However, we do not agree with the findings in Kodala that if a person, that is important, that if a person invokes provision of section 163A, the annual income of rupees 40,000 per annum shall be treated as a cap. In our opinion, the proceedings under section 163A being a social security provision, providing for a distinct scheme, only those whose annual income is up to 40,000 can take the benefit thereof. All other claims are required to be determined in terms of chapter 12 of the Act. No, that's what you said. So you were like your income is 10,000. You cannot do it. Whatever any illegality that. What are you trying to say, Mr. Counsel? Any 1 minute, any order that is passed by this court in ignorance of the order passed by the Supreme Court has to be upheld? I don't think that's a law. That's not the law. So let's be on law. No, this is, once you look at 67 para number, in so many words, they said that the law laid down in Kodala's case, where they have given such a permission to have the cap of 40,000 is bad. Unless and until your annual income is below 40,000, you cannot have an application under 163A is the law. If you have any other Supreme Court judgment, that we have to look at. Yes. Unfortunately, we cannot discuss on that in the light of this.
There is the amendment notification I have raised.
No, they have also discussed with the amendment in the entire judgment. What was 141 earlier? Which says. Your OP is when? When is your OP? So you can't have, we are deciding the legal. No, we are looking at something of the legality or otherwise of the order passed in so. As on that day, there is an order of the Supreme Court in 2004. So if you can get the judgment or something, we can look at that. What is the other judgment of the Supreme Court? So what will happen? No, let us assume that. No, you can't, because your income is above 40,000, you cannot make an application. That is there. I'm talking about the eventuality where a person has, there was an accident, his income is above 40,000, and yes, under the, then where will he go? Because there is no negligence aspect in that.
Approximately.
Please try to look at the judgment.
May I have a submission made in this regard, my lord?
Yes.
After Deepal Girish Bhai's Sony's case rendered by the 3 judges of the Apex Court, a division bench of this court has reiterated the same legal position. If someone's income is more than 40,000, if it is claimed as such, there can't be an application under section 163A. Lords have just now read in explicit terms, the Apex Court has held that it's a social welfare measure within another social welfare measure, which the Parliament enacted by incorporating section 163A.
Yes.
It is a code by itself. It is not attached with either section 162B, section 140 or 166. It will be a structured formula worked out under schedule 2, analogous to 163A. It was intended to provide succor to those families whose victim was one of the drivers or riders, as the case may be, where two vehicles are involved.
Yes.
If the driver of a car is exclusively negligent in causing the accident and he dies out of that accident, hitting against another vehicle, they were without any remedy under section 166. In its wisdom, Parliament provided for not only 140, they worked out a structure formula. It has to be looked as if it is a mini statute by itself. Irrespective of his negligence, which cannot be proved, we contended earlier when 1984 amendment came. Though they are not required to prove the negligence, even under section 163A, the owner of the other vehicle or insurer are entitled to establish the negligence of the victim himself. That was not accepted. Now it is confirmed by the apex court also.
What about your matter?
In this case, the income claimed was 10,000 per month. In spite of amendment, it remained to be so because his income cannot be reduced only to deceive the statute. If somebody is getting 50,000 salary, a claimant is required to come to the court with clean hands.
Take up your matter also on Tuesday, the same issue.
Tuesday,
Yes, please.
otherwise also, my lord, to differ again, stare decision comes in the way of this sound court, where if there is a decision of the division bench of this court, to have a different opinion, my lords cannot be having it.
No, there may be, let's see if there is another Supreme Court judgment.
Now, if it is, my lord, so far it has not come to my knowledge. I will also
We'll
learn.
see on Tuesday. We'll see.
If law is decided afresh with reference to Deepal Girish by Sony's case by a larger bench, more than 3, then my lord should be justified in giving them the relief.
Yes.
On Tuesday, my lord.
Tuesday.
Serial number 24, N. Venkatesh.
Yes, Mr. Venkatesh.
My lord, I am appearing for the appellant insurance company, my lord.
Yes.
Appeal is on liability, my lordship.
Yes.
My lord, this is a major issue in this. I have not issued a policy and the data of extent to the insured, my lord. So,
did you take that stand in your
yes, I have
statement?
taken that stand. I have examined my para 3 may kindly be looked into my return statement.
No, let us go to the finding of the court, how the court has discussed.
My lord, kindly come to the issues framed by the learned judge at page 5.
Yes.
Issue number 2 is whether second respondent, number 2 insurance company, proves that there was no policy coverage in respect of tractor trailer so and so as on the date of extent.
Come to issue number 2.
Page number 5, my lord, issue number 2, issues number 2, my lord.
Yes.
Page number 5, first issue is that is 2 is my issue. And for that answer, learned judge gives to next page, issue number 1 and 2 affirmative.
No, come to page number, para number 8.
Okay, please. Issue number 2, that is para number 8. As I have already said, the above petition has proved that the accident has been taken place in the place, date and time alleged, due to which the Baswaraj is died. Petitioner have also proved that the accident is due to rash and negligent driving of driver of tractor and trailer. It is not in dispute. Respondent 1 is the owner of the vehicle. Respondent 2
It is not in dispute. It was insurance.
accident is not in dispute, my lord. Even today, I am not disputing that accident. Respondent 2 is the insurer of the vehicle. Hence, both are liable to pay compensation. First petition is the father, second petition is the mother.
What is exhibit R1?
My lord, kindly come to exhibit R1, my lord.
Give the record.
That is the policy which I have issued, my lord. R1 to R4, I have examined the officer. I have marked exactly R1 to R4. Actually, it is marked as exhibit D1, my lord. Exhibit D1 is said to be, though it is marked as R1, D1. Timmaya, ICICI Lombard Insurance Company, certificate of policy cum insurance. Kindly come to left side, period of insurance.
1 minute, 1 minute.
Please, my lord. Chandru. Iದೇನು ಶರತ್ ಗೌಡ ಅವ್ರದ್ದು. Got it, my lordship?
1 minute.
Please.
ICICI Lombard.
Yes, my lord. Left side, second policy issuing office, next period of insurance. 000096/2008 to 86/2009 midnight.
Policy issued on 22.
9608 to 8609.
No, period of insurance is from
9608 to 8609.
96/2008 to 86/2009.
Exactly, my lord. But date of accident is 2608.
Accident date is
2608, my lord. On that date, insured vehicle is not covered by me.
cover note was issued when?
Please exhibit, come to D2, my lordship. Next page. The first column, data entry, date 6908. 6908. Next, come to D3, my lord. On the same page.
No. Let's have the date on D2. D2 date is 6/9/2008.
Yes.
How can it be?
No, file receipt date 6908.
File received date 6/9/2008.
Yes.
How can it be?
No, date of exit 2608. I have
Instrument date is 6/4/2008.
Yes, my lord. Chandru. Yeah, Papa.
You received the payment on 6/4/2008. You received the payment on 6/4/2008.
Not payment, my lord.
Amount check.
Illi, my lord, manual entry admele accepted, rejected nodi. Rejected have in the last fourth column. Print idiyalla allinda kelagade last banni rejected. And further D4 may kindly be looked into, my lord. Proposal, motor proposal forum. Owner is Timaya. Tractor and trailer.
What is D3?
B3 is the break in inspection certificate. That is recommended date 6408. Some left side, madam, sublocation Bangalore. Recommended date is 6408. Policy may kindly be issued. The following vehicle, Mahindra.
So recommendation was 6/4/2008.
True,
According
my
to you, you are granted on 9/6/2008 after 2 months.
Correct.
And you
Because
received the payment in April.
no, my lord. Come to motor vehicle proposal form. What is the proposal form? Exhibit D4. When the proposal was received, when I have accepted it.
Yes.
My lord, column number 4, column number 3, effective date and time of commencement of insurance for the purpose of the Act 9/6/2008. Date of expiry of insurance midnight of 8/6/09. Signature of the proposer at the last end, my lords could also see signature of the proposer, Timaya.
Then court has not discussed about this evidence.
No, that issue, though it has held in my favor, that issue was not discussed by the learned judge, my lord. Nowhere in the
Held the insurance company liable.
Yeah, definitely, my lord. That I will read to my lordships.
Ordinance counsel for the appellant posts this matter for judgment day after tomorrow.
Please, my lord.
No representation on behalf of the respondents.
And one more citation of this honorable court, which was held that it is for the claimant or the insured to produce a policy is reported in ILR 1997, Karnataka 1051.
No judgment is required for that.
Please, my lord.
Yes. If you go, respondent. Morning, they asked for a passover.
I am for the appellant.
Yes.
It takes little time. It may kindly be had next week, so that it's a misrepresented claim. The earliest medical records show that he was occupant of a tractor, met with an accident, suffered fatal injuries. Thereafter, they changed the version to implicate a two-wheeler. Happily, some villager of our neighbor or relative has lent his name. So vehicle is fixed in the accident.
With the request of land for the appellant, post on Wednesday. Thursday is not Wednesday, sir. Yes. Item 39. He only appeared, no, Sitaramana. Please, here and he appeared online. No, that's what, no, just so he appeared online, DC Sitaramaro.
I am here, madam.
Yes. Item 39.
Yes.
Yes.
39, second matter.
One minute. Do the file.
You know. 2014.
Here the order is one and the same. No? So,
Virtually same, my lord. Here the motorcycle rider dies, his own negligence. Subsequently, Jeep is implicated. Tribunal gives undue weightage to the police charge sheet and holds that the other vehicle, Jeep,
so
was
now
involved.
this, there are how many? 4 appeals. What are now? Let's see the MBC numbers from the order. No, there are 2 claims. One is 1744.
And 1745.
So, what is the 1 minute? 1 minute. What is the appeal of the claimant against 1744? 1485. What is the insurance company appeal against 1744? 24
71.
Then against 1745, what is the number of claimants appeal?
72.
1484.
1484. And the insurance company's appeal? 2742 of 15. Which case is, which MBC is case of death?
1744.
Death. Let's please come to the order. What was?
The claim in the petition was 30 lakhs.
Hmm.
The amount granted was 11 lakh 31,000.
31,000? Let's see. They were both of them were traveling
They were traveling in a car.
in a bike. Who is rider and who is a pillion rider?
It was
The rider. Hmm. Yes. Let's please come to the. Your insurance company is questioning the liability or the quantum.
I
I am on liability, my lord.
You are questioning the liability.
Yes.
Yes. First, let's go to the liability aspect.
Number 3.
Please state.
If the court is hearing on liability, I would be making my submissions.
It can make. Once a liability issue is heard, then we'll hear on enhancement of compensation.
Please, brother.
Because his appeal is on liability, let him argue.
Kindly see.
Yes.
Fifth respondent in this appeal is one Srinivasa Pujari. He is the fifth respondent in this appeal, who was the first respondent in claim petition. All of them live in the same house. Kindly note this aspect. Claimants as well as the fifth respondent live in Jyoti Ballu house, Bondala, Pane Mangaluru village, Bantwal Taluk, Dakshina Kannada. That's where the mischief emanates and it smells rat. These two boys were riding motorcycle. There was an accident without involvement of any other vehicle. A person living with them becomes a tortfeasor. He is the owner of it. And they are trying to snatch the compensation from the insurance company by getting the police records manipulated. The second aspect which the court has to notice is, their case is that a goods vehicle dashed against the motorcycle. The IMV report would not justify such a ghastly accident. The nature of damage that would be caused to a two-wheeler when goods vehicle dashes would be totally different. Kindly have a look at the IMV report also, which is available on record.
No, before that, please come to the issue where the court has discussed about it and how the court has held that you are liable. Where is
Please,
that?
In page 15 of my appeal papers, it commences from para 12.
Yes, please read.
Since these issues are interconnected to each other, I have taken them together for my discussion in order to avoid repetition of facts. It is the specific case of the petitioners in these cases that accident occurred on 19/9/2011 at 8:15 a.m. at Shanti Angadi B. Moda village, Bantwal Taluk, on account of rash and negligent driving of the driver of the Mahindra pickup jeep bearing number KA01C2491, and due to which the deceased Jeevan B, the rider of the motorcycle bearing number so-and-so, and pillion rider Kirtan Kumar Naik got sustained injuries and rider has succumbed to the injuries on the spot. These facts have been flatly denied by respondent number 2 in the written statements, contended that the accident was not occurred due to rash and negligent driving of the driver of the vehicle bearing number so-and-so, but the accident was occurred due to rash and negligent driving of the rider of the motorcycle bearing number so-and-so. That to prove the case of the petitioners, over 7 witnesses has been got examined and got marked Exhibit P11 to P33 documents. All witnesses in their examination in chief categorically contended that the accident was occurred due to the rash and negligent driving of the driver of Mahindra pickup jeep bearing number KA01C2491. So also they have relied various documents, among them P1, P2, P4 to P7 are important for determining these issues. Exhibit P1 is the FIR and P2 is the complaint. P4 is the notice under section 160 of the MV Act. P5 and P6 are being spot measure with sketch, and exhibit P7 is the charge sheet in respect of the accident. On perusal of the contents of the above documents, it appears that the concerned police, after due investigation, have charge sheeted the driver of Mahindra pickup jeep number so-and-so involved in the accident for the offence punishable under section 279, 338, 304A of IPC, and also under section 134A(b) of the IMV Act. Neither the driver of pickup jeep nor anyone has challenged the final report submitted by IO in respect of the accident. That the respondent number 2 has flatly denied the contention of the petitioner and set up specifically that the accident was occurred due to the rash and negligent driving of the rider of the motorcycle bearing number so-and-so. Therefore, the claim is not maintainable. The pickup jeep is falsely implicated. In the present case, in this regard, the respondent has examined on all 2 witnesses and got marked exhibit R1 R17 document. On perusal of Exhibit R1, intimation issued by the hospital authority to the concerned police about the alleged road traffic accident disclosure that one Kiran, brother of the patient, admitted the petitioner in MVC 1745 of 2011, Kirtan Kumar, to the hospital, stated about the road traffic accident. R2 is the letter written by one SP Hegde, the investigator of insurance claims disclosure that on inquiry, it is learned that both the above said persons are close relatives living together at Rangelu. To confirm the same, he has visited the Bantwal Taluk office and arranged to obtain voters list. That this is what I submitted in the beginning itself. Claimants and the owner come accused of the accident live in the same house. Relied on Exhibit R3. On perusal of contents of Exhibit R3 does not support the contention of respondent to neither the authority who have prepared the Exhibit R3 nor any related persons have been examined. Therefore, mere filing of document does not amount to proof of documentary argument seems to be reasonable. Even for the sake of argument, the contention of the respondent number 2 is taken to be true that family members are close relatives. Not only, my lord, I will stop here for a moment to add my impressions. They live in the same house. Court wants me to prove it beyond doubt. Claim petition, first respondent's address is the same. In this appeal, fifth respondent address, I have furnished the same house address where he has been served.
Yes.
Further, it is contended, para 15 minutes, that the respondent number 1, being close relative of the petitioners and they are belong to same family, that the documents relied by respondent number 2 is totally insufficient to come to the conclusion that the petitioner and respondent number 1 belong to one and the same family. That they don't dispute. Cause title, why did they give their house address? Claimants and the tortfeasor. Court wants me to prove beyond reasonable doubt how relationship exists between them. Further, the pickup van alleged to be involved in the accident is falsely implicated and it has no nexus with the accident. Therefore, the petitioner's claim is unsustainable. Even for the argument's sake, the contention of the respondent number 2 is taken to be true that the petitioner and respondent number 1 belong to one and the same family. The responsibility cannot be overruled. That based on the voter list, the contention of the respondent 2 is believable. Further corroboration is not brought by him. I have brought corroboration, same address. On perusal of the voters list, it discloses that the door number of the petitioner respondent number 1 are quite different, which support the contention of the petitioner that they are residing separately. The door number of the respondent number 1, Srinivas Pujari, is 21-167. Shown in the list. On the other hand, the door number of the petitioner deceased Jivan is 21-167A. Shown in the said list. Hence,
Do you have the copy of the claim petition?
yes, minutes.
To see what was their case?
Let's, I will first take the case of 1744 claim petition. ಈ ಮನುಷ್ಯ 70 ಪೇಜ್ ಒಪಿನಿಯನ್ ಕೊಡ್ತಾನೆ ವಸಂತರಾವ್ ಈ ರೇಟರ್ ನ್ಯೂಸ್. Sorry, my lords, I'm just looking for claim
Yes.
petition copy in a very big file.
Hmm. When in the claim petition, when they themselves have furnished the address, why such a big discussion by the court saying that the insurance company has failed to prove? No, let us not go to exhibit. This claim petition is filed by you. Where are, no, where are the numbers? Your cost title. Then where is it one? Where is it given?
They are produced. The insurance company has produced. What is this? That is
No, cost title is given by you, sir. In the same address, I have got him served also in this appeal.
Who was driving the vehicle? Who was driving the vehicle?
this is
No, the offending vehicle.
what is this?
That is Srinivas Pujari was driving. He's the owner of the vehicle. When the complaint was given on the same day, what is the date of accident? What time?
8:15 AM on 19/9/2011. Could my lords get the petition, my lord? Now I have on my hand.
Yes, I have seen. I was looking for the address and anything with regard to their relation and all, whether they know the owner of the vehicle or something they have stated. I was just looking at the claim petition.
If they had come, my lord, if the accident were to be true, they could have stated that. Evidence is not in consonance with what the police records speak. And the next day they create all this theory. They have not found anybody. Then they found Srinivas Pujari in the same house. Probably the vehicle belongs to the same family. My policy, which I have produced, also shows the same address. They give contradictory evidence in the criminal case also, where the driver has been acquitted.
In the cross-examination, any suggestion was given?
To whom, my lords?
To the claimants about the relationship of the owner.
My lords, I'll first Balakrishna claimant, Kirtan Kumar Naik. PW2 is the claimant injured. He was CW4 in the criminal case. He turns hostile.
Evidence of PW.
PW2, my lords.
Yes.
I'll read his cross-examination only without troubling the court for chief.
Yes.
But unfortunately, my lord, it is in Kannada.
Entire evidence is in Kannada.
Yes, good.
MLC register is what?
That's a private hospital, a small hospital, has shown it as RTA.
For the first time, when was the number of the vehicle was mentioned?
Next day, my lord, though the accident occurred 8 in the morning, next day, police complaint is given.
19th is the date of accident.
Yes.
Same date, 11 o'clock is a complaint.
What?
Look at it.
One second, my lord, I'll just check. Copy of the FIR I'll check.
Same date, 11 o'clock.
it makes no difference because they live in the same house, self-accident, immediately they have planned. They don't go to any public hospital. Date 19/9, yes. At 11 o'clock, complaint is lodged by one Prashant of Ishwar Kotari.
Person who was. Yeah. Yeah, produce a document, give the details of. I mean, repeat.
At what time they are given the intimation? Exhibit R1? Exhibit R1. Accident is at 8 o'clock. On behalf of respondents, all these depositions are marked. For what purpose? Who is Kirtan Kumar?
Any boxing manner, any for them. Cannot be considered. Maybe the.
Who were the eyewitnesses to the incident? Were there any eyewitnesses to the incident?
No.
Pillion rider.
His evidence will destroy everything.
What he says?
Lord, he says he has not seen the vehicle. He says the goods vehicle did not suffer any damage. Then he says after 2 months, Mahazar was drawn.
PW says, what is PW2's name?
Lord, I'll read that portion, Lord.
What is his name? He says he has not even seen the vehicle. No, criminal
what he
case
says.
or a civil case, that is how does it make difference? He's a pillion rider. He says he has not even seen the vehicle. Why will they say?
The doctor says he was conscious, but this fellow says after the accident, I could not see. First, he says there was no damage.
So to prove the involvement of the vehicle, who was examined? He says he has not seen the vehicle.
No, he says no damage was caused to the goods vehicle.
That is in Kannada. What he says?
Instead from 99 to go to the low, at about 1850, I was proceeding.
No cross-examination you have to read, sir. Para 2 of his cross-examination.
One, K01 C, and came to the opposite side. And the side was the side.
Which para of the cross examination? No, cross examination. You was referring. Which para?
Para 2 minutes.
Para two, please read.
Yes. First word, first sentence he says is, no damage was caused to the vehicle which caused the accident.
Hmm.
Within 5 minutes, I was taken to the hospital.
Hmm.
I do not know who broke the glass of the vehicle.
Hmm.
After 2 days of the accident, police came to hospital and showed me the mahazar. He says, I do not know why in the mahazar the vehicle which caused the accident is not mentioned. After 2 months, police seized the vehicle, and that fact I came to know. I could not identify the vehicle because I was in shock.
But he says in the chief affidavit that he has seen the vehicle.
I am reading from his evidence minutes.
Chief cross examination.
First word he says is, no damage was caused to the vehicle in question. Second fatal answer he has given is, within 5 minutes from the time of the accident, I was taken to the hospital.
You file the translation of the evidence of PW1, PW2, and RW1. Because it has to be considered, there is no, let's forget about the respondent's evidence. Now, your accident has taken place, about the involvement of the vehicle, rash and negligence, that's a burden lies on the claimant. So how you have discharged it is a question. That we will see. You please find those. When can you find? PW1, 2. The chief examination anyway is in English, cross examination.
But chief examination, it is we the lawyers who prepare. It is the party who deposes in the cross examination.
No, it's not required. This is a big fact. A week. Post on Thursday.
Madam, court officer, madam. Court officer, madam. Court officer, madam. Court officer, madam.
ಹೇಳಿ ಸರ್.
Madam, 47 tomorrow again, serial.
ರೀಚ್ ಆಗದೆ ಇರೋದನ್ನ tomorrow ಸರ್.
Okay, thank you, madam.